The next case to come before the court is Miguel v. Robert Alderman. You will have up to 15 minutes for your argument, and the arguments are being recorded, so please stay behind the podium and keep your voice up. And please do not use the names of children or victims should that arise here. And the judges have read your briefs and are ready to proceed when you are.
Thank you very much. If it please the court, I'm in the unusual position of saying I don't need to reserve any time for rebuttal. Unless I said something wrong, I might have to rebut what I said. I'd like to begin my discussion. The court has read the briefs. I'd like to quote out of Appellee's brief, where it says, he states at page 11 that sufficient evidence must be presented in order for a party to rebut the presumption of service. The problem for a hunt, that is to say, the plaintiff appellant. The problem for a hunt is that such evidence was presented and he has not rebutted it. Goes on to say at the last page of his brief, the trial court's decision was supported by competent and credible evidence which went unchallenged by Hunt. The trial court did not abuse its discretion in so finding, and this court should not reverse that decision. I'm kind of baffled because it says that the court should be affirmed because we did not offer evidence to controvert the affidavits that were submitted in this case. And the fact of the matter is we did not offer evidence to dispute that because the affidavits themselves that were submitted by the defendant established proper service in this case as found by the trial court. I'd like to pay attention to court, bear with me, I'm going to read from the trial court decision at page A6 of the attached to my appellant's brief. In the 9th District, certified mail need not be delivered to and signed by the addressee only in order to be effective. Goes on to cite a number of cases. Consequently, the court finds that plaintiffs complied with the Ohio Rules of Civil Procedure. When a party complies with the service requirements of the Ohio Rules of Civil Procedure, a rebuttable presumption of proper service arises. However, the presumption is rebuttable only if the defendant presents credible evidence that he or she did not in fact receive the summons and complaint, citing Buckingham. In this case, the defendant testified he became aware of the complaint in early June of 2019 by Alderman Sr., who is his father. Moreover, Alderman Sr. testified, by way of affidavit, for this on the side, he gave the complaint to the defendant in early June of 2019. As such, the court finds that defendant failed to present credible evidence that he did not receive the summons and complaint. In fact, I would submit that the evidence is undisputed from the affidavit of his father that he did receive the summons and complaint. And it's curious because in his own affidavit, he never denies that. Quote, consequently, the court finds the plaintiff properly served the defendant. So if we're talking about the court's findings are that there was good service in this case, and it was not rebutted by the defendant. Why? Because contrary to getting an affidavit and stating that he never got it, his father's own affidavit, which he didn't dispute, states that the summons and complaint were delivered to him by his father within a few weeks of the filing of the action, the refiling of the action.
Did Hunt know that Alderman didn't live there?
Hunt maybe didn't, and he looks to his attorney, and I will be the first to admit that that's where he originally lived at the time of the first complaint. I dismissed the first complaint without prejudice. I did not go back to read the deposition transcript before refiling the case. There is a statement in there that he had moved to a new address, and that was years earlier, and when I went to refile the complaint, I just took the original template off the original complaint and refiled it. So there's evidence in the record from a deposition that had been taken years ago. By the way, this case is a very old case because it was taken up twice by the defendant on the denial of summary judgment motion, and both times this court affirmed. So the deposition was years before, and I would freely admit that I just sent it to the address, which happened to be the apartment his father owned where he was living at the time of the original suit. And what happened then is when the suit papers got to the tenant, it said Robert Alderman, and delivered them to the father. And so I said, oh, these aren't mine, these belong to my son, these go to my son, and then he hand-delivered them to his son.
Thank you.
So, but I guess what I'm submitting for the court is where the trial court has found that service was proper, and the trial court has found that there was no rebuttal, and what you have is due process, I would submit, comes into play, where you have a presumption of good service, and the defendant then comes and says, there might be a presumption, but I never got it, you know? So here, there's a presumption, it went to this, you know, was served at this address, and under the rules, that's, you know, presumption of good service. Well, I moved years earlier, that's not good, I never got the papers. They were never delivered to me. The summons and complaint were never delivered to me. Consequently, due process says, then you vacate a default judgment or whatever, saying the person never got it. This decision of the trial court should have stopped right where I finished reading it, which is that you didn't rebut the presumption of good service. You admit, or your father admits to giving you, and you don't dispute, that you got the suit papers within a matter of weeks, that they were delivered to the father, and he in turn delivered them to you. And so then the trial court goes on to say, well, I'm also going to determine that this was not reasonably calculated to apprise him of the pendency of the action. And I would submit that that analysis doesn't belong in this case. And the reason it doesn't belong in this case is you don't have, you may follow the rules and the person can still come in and say, you know, I was overseas and I didn't get it and that's not good service, and you've rebutted the presumption. But in this case, the defendant did not only not rebut the presumption, his own evidence that he submitted to the court and upon which the court made its finding was that he did receive the summons and complaint. And I submit to this court that in all my research, I've not found a single case, and defendant, in their brief, don't cite one, where you actually have good service, proper service, a presumption of service, and not only do you have the presumption, the irony here is the evidence that the plaintiff, the defendant then submitted to rebut the presumption only reinforced it, that, yeah, he got the suit papers in a matter of a few weeks. That should be the end of this analysis. So with that, I know you're pressed for lunchtime, but I don't know what else to say. I read this and I go, why are we even getting into due process when there's not been a rebuttal of the presumption? This man's due process wasn't denied. He had those suit papers right in his own hand within a matter of weeks. And they were via his old address, which was forwarded or delivered from the tenant to his father who gave them to him. So on that, I rest. Thank you very much.
Thank you very much, counsel. Thank you for your presentation.
I apologize.
We will take this under advisement and issue a decision in this case in due course. The clerk of courts will mail a copy of that to you on the day it's released, and the opinions will also be posted on the Ohio Supreme Court website.
Thank you very much.